and oftentimes there's no regulation at all. That's the case in Texas. Our alternative dispute resolution statute is about 10 pages long, and there's no regulation. Our statute mentions mediation by name exactly once. And so there's not a whole lot of regulation. And so in the United States, most of mediation is developed in the open market, and we've had much more flexibility to develop mediation in a way that parties and the mediators have found appropriate without government guidance or interference. Mediators in Latin American countries oftentimes tend to be government employees, whereas most mediators in the United States are private practitioners. There are some government mediators who work for, the example, the Department of Justice, the Equal Employment Opportunity Commission, and others employ mediators, but they also employ external mediators, and they tend to employ more external mediators who are private practitioners than their own employees. In the foreign countries, mediators tend to have much more training than we do in the United States because the government is funding and the government is basically, in many cases, training its own employees. They require a lot of training of their own employees and of private mediators. In the United States, you don't have to have a whole lot of training as a general rule to begin practicing mediation. I've already said in Texas, the only training you have to have in order to be a mediator and receive an appointment from a court is 40 hours of basic mediation training. And then if you want to do family cases, you have to have 24 hours more, but that's it. In Latin America, it's not unusual to require hundreds of hours or at least 80 or 90 hours of training in order to be a mediator. In Latin America, the mediators tend to have government credentials, meaning that they have a certificate or a license, practically, to mediate. All right, and they're very proud of those credentials. In the United States, we don't have that. We don't have government certification or credentialing of mediators for the most part. And so to the extent that we have any credentialing, we've developed our own credentials through private organizations. In Latin America, lawyers tend to receive more privileges as mediators. There tend to be more limitations on who can be a mediator. And the people who are usually allowed to be mediators are lawyers. And if a country decides to open it up to people who are not lawyers, it tends to be very limited. The types of cases they can mediate are very limited. Whereas in the United States, there's very wide acceptance of mediators from a variety of backgrounds. I will admit that lawyers in the United States do have an advantage over people who don't have law degrees and licenses. And that is, a whole lot of the mediation, particularly the more lucrative mediation, occurs in litigated cases. And typically judges and lawyers want other lawyers to mediate their cases. But in Texas, for example, if someone who isn't a lawyer can persuade the lawyers or the judges to appoint them, the law doesn't prohibit them from mediating a case that's actually in litigation. Another thing I've noticed is that mediated settlement agreements in Latin America oftentimes are the equivalent of court decrees, because it's so highly regulated and the people who are mediating are lawyers. When they write an agreement, that oftentimes ended up being the equivalent of a decree. In the United States, because so many mediators are not lawyers, the typical thing is that the mediated settlement agreement has the effect of a contract, but it's not a decree. And then I think I have one more slide. And that is that change occurs slowly and is less flexible in the in Latin America, whereas in the United States, because we don't have that much regulation, the profession can change rapidly and we could do things more quickly. A current example is the use of online dispute resolution or online mediation. In the United States, because we don't have much regulation, when the courts shut down and people stopped moving around, we mediators in the United States started doing our mediations online through Zoom, and we didn't require government approvals to do that. Whereas in Latin America, because there are so many regulations, the mediators have to go through this long process of changing the regulations, getting government approval before they can do mediations online. And in some places, that still isn't happening. And then the last thing is that mediation grows under governmental supervision in Latin America, whereas in the United States, there's little governmental supervision. What does government, though, is the market. If you're not a good mediator, you're not likely to be mediating long because the market will kill you. And then my last slide is just a thank you from me. There is my contact information, my telephone number, my email address. Any of you are welcome to contact me if you wish. Mr. Nag has this PowerPoint presentation, and so if you want it, I'm authorizing Mr. Nag to send that PowerPoint presentation to you if you want. And if you want it from me, if you want to communicate with me, you're more than well to write me at that email. Okay, and so next, I guess I'll just ask for any questions or comments that you have. And thank you very much for this opportunity to speak with you.
Thank you, Dr. Wright. There are questions. I would read it out for you so that it is easy for you. The first question is, how can the award differ from one such mediation or arbitration arranged? And can this feature be malpracticed?
I'm sorry, but I didn't understand the question.
Shubham, if you can rephrase. I believe, sir. Am I audible?
Yes, I can hear you. I'm clicking the chat feature, but it's not showing me anything.
So I believe the question which he wanted to frame was that whether there can be any difference, like from one arbitrator or one mediator, whether order can differ from one mediator and one arbitrator to another, and whether there can be any malpractice attached to it.
Okay. There are definitely differences between arbitrators and mediators because there's not that much regulation of, particularly of mediation, and because both arbitrators and mediators can come from different professional backgrounds. You certainly have high degrees of difference between mediators and arbitrators. Now, there are special arbitration laws that do govern particular things in arbitration, like disclosure of conflicts and not having private meetings with parties. And so if an arbitrator, for example, doesn't disclose a conflict or has private meetings with just one party out of the presence of the other, that is a type of malpractice, and it can have the effect of voiding the arbitrator's award. And the arbitrator could even be subjected to a lawsuit if there are damages. In mediation, we have a wide variety of mediation models, which I haven't even discussed today. We have the transformative mediation model. We have the facilitative conference model, the facilitative caucus model, the social justice model, the evaluative model. And so whenever you select a mediator in the United States, it's very important to understand the model of mediation that the mediator will use, because the parties are in charge of that. Our laws leave it to the parties to pick their mediator in most cases. In terms of malpractice, there aren't many ways that mediators can be subjected to malpractice, but there are a couple. probably the primary one would be revealing confidential information. In mediation, parties can meet privately with the mediator, and oftentimes when the parties are meeting privately with the mediator, they do reveal important confidential information to the mediator, and they ask the mediator to keep the information confidential. And so if the mediator receives confidential information and then discloses it to the other side without authorization, that would be malpractice, and the mediator could be subjected to damages for that. Another thing that that potentially, I mean, it's not really malpractice, but the other important pillar of mediation is impartiality. Mediators are not supposed to favor one side or of the other. And so if parties sense that the mediator favors one side or the other, they're likely to withdraw from the mediation, fire the mediator, and get another mediator. But because the mediator doesn't make a decision in the case, that's not necessarily something that is going to give rise to a valid cause of action for damages.
So the next question is that whether there is any difference with regard to the awards made by an arbitrator arranged by the court or an arbitrator arranged privately. Like when two parties are arranging for an arbitration for themselves or a mediation for themselves, and the court orders for arbitration or a mediation, whether there would be any legal difference to that effect.
Well, first of all, as far as arbitration goes, a court can only order arbitration if the parties have already agreed to arbitration. That's the limit of the court's authority. Courts get involved in enforcing agreements to arbitrate only if the parties, if one party has signed an agreement to arbitrate and doesn't want to do the arbitration for some reason, like fraud or duress. And so that's where courts get involved in arbitration. They typically don't name the arbitrator. The parties select the arbitrator. Or an organization like the American Arbitration Association gives the parties a list of arbitrators, and the parties pick the arbitrators from that list. In mediation, the court can and sometimes does name the mediator, but in Texas, the orders say if a court orders mediation and names the mediator, the order also says that the parties can pick their own mediator if they want, and that the mediator named in the order is only the mediator if the parties don't agree to someone else. And so the parties generally have a lot of control. Now, in terms of the effect, an arbitration award is an arbitration award, regardless. As I mentioned, arbitration only comes about if the parties have already entered into an agreement to arbitrate. In Texas, the only thing a court can do is order the parties to attend a non-binding arbitration. The court can order non-binding arbitration, but the court cannot order binding arbitration unless the parties have agreed to it in advance. And then in mediation, an agreement is an agreement. If it's an enforceable agreement, it's enforceable, and it doesn't matter whether the mediator is appointed by the judge or whether the mediator is someone that the parties have elected.
So the next question is, it is not a question per se, it is regarding your opinion. Like in United States or in Mexico, in Argentina, the ADR concept has taken up a lot of footing there. But however, in India, we are developing the concept, but it is not as frequent or as impressive as of the United States. So if there is any comment of yours with regard to this particular aspect, that India is still not in a growing state of ADR, whereas some other countries have already.
Okay, well, let me talk a little bit about this, because the growth of mediation in the United States is a result of something, is a result of a bit of a contradiction, and that is mediation is supposed to be voluntary, okay? But under our mediation laws, the courts can actually order people to go to mediation. And so that's a bit of a contradiction, because in my view, mediation would not have grown as much as it has grown in the United States if the law had not authorized courts to order people to attempt it. Because I was a mediator before the law passed, I was a mediator, and of course I've been a mediator in the 33 years since the law passed. And it makes a difference if courts can require people to mediate. The big difference, though, is that once people are in mediation, the court has to step back. The court does not interfere with the mediation, and the court cannot, at least in Texas, cannot even require the parties to negotiate. The court can order the parties to show up for the mediation, but the court cannot require the parties to actually negotiate during the mediation. So now, and it's the same thing in Latin America, is that mediation, as a general rule, was very small, did not exist to a large scale until there were orders, until the courts were permitted to order people to mediate. That's when mediation really grew. But again, even in Latin America, the courts can encourage people to mediate, they can even order people to mediate, but they can't require people to, they can't govern people's behavior to a large degree once they're in mediation. They can't require them to make an agreement. So I really think if you want to see substantial growth of mediation in India, and there isn't now, you basically need a law that authorizes courts to require people to mediate. And that will be the push that will open people's eyes to mediation, particularly people who aren't lawyers. People who aren't lawyers like mediation more than people who are lawyers, particularly at the beginning, because lawyers tend to fear that if cases go to mediation and settle, then there won't be anything for the lawyers to do, that everyone will mediate instead of litigating. But I can tell you that has not been the case anywhere where I've seen mediation. In Texas, for example, there are still just as many lawyers. In fact, there are more lawyers in Texas now than there were in 1987 when our law passed. The lawyers have plenty of business, and lawyers generally have a favorable view of mediation in Texas because it's so effective. And lawyers do very well in Texas. They haven't lost a ton of business because of mediation. They've got a different type of business because of mediation, because parties want counselors as often as they want litigators when mediation exists.
Sir, since you have a huge experience in your life, would you please suggest some key features to the upcoming mediators which leads them to do better?
You need a lot of qualities in order to be an effective mediator. There are a lot of them, and it almost sounds, when I describe the qualities you need, it almost is like I'm describing a divine individual, and mediators are not divine individuals, but you need a lot of the qualities that are associated with divinity. In other words, you need a lot of patience. You need an open mind. You need empathy. You need to be able to understand the difficulties that parties are going through. You need to be able to listen actively to what parties are telling you. You need to listen with an open heart and an open mind. And you need to be capable of not judging people, because when people are coming to you, oftentimes they've made mistakes. They've done things that violate the law or that are wrong. And so you need to see them as fellow human beings and not as bad people, and certainly not as criminals, even though they may have committed a criminal act. So it also helps to be curious about people. It helps to be someone who likes people and is interested in hearing stories. And I think you also need to have a sense of public service, because a lot of times when you're mediating, you're not making as much money as you might make as a lawyer. But at least in the United States, we do make money for the most part when we mediate. It's not as lucrative as being a litigating attorney, but the sense of satisfaction that you have when people resolve a case themselves, when people resolve a case through their own intelligence, their own ability, it's very satisfying to see people do that.
So the next question is, criminal law is very, the next question is, the criminal law is very strict to its interpretation. Do you consider alternative dispute resolution as an effective remedy for criminal justice system?
It is used to some degree in the United States and Latin America. It's used primarily in juvenile cases involving people under 18 years of age who have committed nonviolent crimes, young people who have committed vandalism of a building, or who have been caught doing destroying property, or things along those lines. And in some cases with juveniles, it's even juveniles who have done things like getting into fights. And the idea behind the use of mediation with juveniles is to keep them out of the court system, is to keep them out of the criminal justice system, so that they get a second chance. So that they have a second chance. And so, yes, it works quite effectively with juveniles. Another related concept, which is widely used in criminal matters, is restorative justice. There is a restorative justice program in Texas that takes place after someone has been convicted of a crime. And again, it's completely voluntary, but the victim and the offender meet and discuss what happened and why it happened. The victim is permitted to ask questions of the offender. You have to be very careful about this, because you don't want to have the parties re-victimize. You don't want to have the offender re-victimize the victim. But it does exist. It requires very special training, and it's quite useful. So if you're someone who's interested in having a criminal law practice and you want to know about how these concepts of alternative dispute resolution work in a criminal context, I would strongly encourage you to investigate the concept of restorative justice. There are books about restorative justice, and it will give you some ideas about how to work with people in more criminal type situations.
So the next question is it wise to go for mediation over litigation if there is power imbalances between the parties?
Well, in the United States, power imbalances exist. And given what I understand about India, power imbalances exist in India as well. It's part of the world we live in. And so I think people should attempt to negotiate, and people should attempt to mediate even when power imbalances exist. Now, mediators cannot solve the power imbalances in the world that exist in cases when cases come to mediators. But there are things that mediators can do to make the mediation process fair. Mediators can balance inequities in power to a limited degree, at least in the mediation, through due process by giving people equal amounts of time and equal rights to speak and to be listened to, making sure that people are not abused, not re-victimized, giving people the ability to separate out into different rooms if one party tries to exert too much pressure on the other party, separate the people so that the party with the stronger position cannot overwhelm the party with the weaker position. So in the end, the stronger party may not make an offer, the offer that the weaker party would prefer. And so at the end of the process, the weaker party has to decide whether to accept what the stronger party has offered or go forward with litigation. What we encourage people to do is to recognize that if a stronger party has agreed to negotiate with you or mediate with you, that party wants something from you. What do they want? And recognize that what the stronger party wants for you is your strength, because you can withhold that. Okay? And so make sure that whatever the stronger party wants, they pay properly for it. That's my thought.
So the last question would be that what are certain tips for the advocates or the lawyers who wants to prepare themselves to be in the mediation practice itself?
I'm not sure I understood the question, but was the question, what can a lawyer do to prepare for mediation practice?
Yes.
And would that be a lawyer?
Yes, absolutely, sir.
Okay. And so if you're a lawyer who is going to be representing someone in a mediation, I would recommend a couple of books to you because mediation is really nothing more than a facilitated negotiation. And there are a couple of really good negotiation books that I believe are useful to all lawyers who want to negotiate agreements collaboratively. The first one is called Getting to Yes. It is based upon research from the Harvard Negotiation Project. And then the second book that I would recommend is Getting Past No, which is written by one of the same authors who wrote Getting to Yes. Those are two very short, accessible, and useful books. I read them over and over again. I've read them lots of times in my life because they have so many good ideas in them about how to make an agreement. And so that's how a lawyer would, in my view, would prepare. That's the additional thing you would do to prepare yourself for mediation, because mediation needs lawyers showing up who are willing to be more collaborative with each other. If lawyers are not willing to be collaborative with each other, there's not a whole lot of hope for the success of the mediation. If you want to become a mediator, you're a lawyer who wants to become a mediator, that's also possible. And I would suggest taking a mediation course, reading books about mediation. There are lots and lots of books about mediation. And so those would be my just initial off-the-cuff recommendations for you.
Thank you. Thanks a lot, Dr. Walter Wright, for being here. I would not hold you much. I know it is early in the morning in Texas, and you gave us such a long time here. Thank you for the wonderful presentation. I would like to tell you and all the viewers that in the Google Meet itself, we had around 215 people, whereas off in the Facebook and the YouTube, we had more than 600 viewers the entire time. So we had already reached like viewers of like 800 people around. So it was a success on our part as well. But I would of course extend a warm thanks to you and to.
Well, I want to thank all of you for attending. I want to thank Mr. Nag for the invitation. It's been a pleasure to work with you.
However, sir, we have kept. I'm sorry.
I think we may have interrupted with you. Would you, Mr. Nag, would you please speak and then I'll respond?
So what I was saying was I would request the General Secretary, Neil Basu, to give a closing address for the day. However, before you leave and before we close for this session, we have decided that we will be closing the session with the National Anthem of the United States of America in the honor of your presence among us. So before I hand over to Neil Basu, I would request you to just share 2 words with regard to your experience that you could address us, like the Indian gathering long records. There is a lot of countries they have already addressed, and I'm happy that we could like had a partnership overseas, and India could hear from you.
Well, thank you very much for the invitation, and maybe there will be more. I did want to let you know that one of the graduates of your law college is a student of mine, and she may be attending. She told me she was going to attend this morning, but her name is Anusmita Pal Chowdhury, and she's actually taking a class from me this summer. And so I wanted you to know that one of your graduates is actually my student now, and she's a great student. I love having her in my class.
So, sir, I'm aware that she's down with your program in Texas State University.
That's wonderful. Send more like Anusmita. We love her.
Of course, sir. I would request Neil Basu to please deliver the closing address so that we can move for the.
Okay. Thank you.
Yes. Neil, are you there? Neil, are you there?
Audible? Hello, I'm audible?
Yes, please go ahead. Yes, you are audible.
First and foremost, thank you very much, Dr. Walter Wright, for sharing such a great global perspective relating to that of arbitration and mediation. And I think that it was an immense pleasure to hear from you. And we were just awestruck by your presentation, what you showed us. And I think Jogesh Chandra Chaudhary Law College, the way it started its 50-year celebration today by way of a 2-day webinar. So it was a great experience, and I thank each and every participant who participated, from law students to legal researchers to professors to legal practitioners all over, not over India, but throughout the world. From many corners, many people participated in this, and I hope that tomorrow we are having the final session in which Mr. Shishwana Bandyopadhyay and Mr. Brett Lovett will be speaking regarding arbitration and mediation. And I hope and trust that it would help all the participants to a greater extent. So thank you so much. A warm regards from the Jogesh Chandra Chaudhary Law College family. Thank you so much. Thank you.
Thank you.
So before you leave, I would request Ashutosh Bhattacharya to kindly play the national anthem of the United States of America. I request everybody to please rise.
Please.
Ashutosh, kindly go ahead and play the national anthem.
Thank you very much for that. That was very nice.
Thank you, Dr. Walter-Wright. Thank you, everybody. Good night and a very good day to you, Dr. Walter-Wright, for the upcoming day. Yes, please.
Thank you, and I guess good evening to all of you in India. Bye-bye.
Thank you, sir. Thank you.
Thank
Good
you.
evening, all. Good night, everybody. Thank you for attending.
Thank you.